may be seated. Good morning, everyone. Good morning. Let's begin first. Timekeeper right here, is that correct? Just make sure we know where we need to look. And welcome, everyone. My name is Michael Montero. I'm a district court judge in the 6th Judicial District, which is up in kind of the northern part of the state, Humboldt, Pershing, and Lander counties. It's a pleasure to be back again this year. I've helped judge the Reader People competition a couple of times, and so it's very nice to be back here. And I'll let the rest of my judging panel introduce themselves.
Good morning. My name is Damian Sennett. I am the Deputy District Attorney with Lyon County. I do most of my work in Fernley as a prosecutor. It's the second time that I've judged the competition, and I'm looking forward to hearing from you this morning.
My name is Haley Summers. I am one of your alumni ambassadors for We the People. I did this program as a high school senior about 3 years ago down in the South. I moved up to Reno when I was accepted to the university, and I was offered the position of ambassador. I hope you guys have a great time today.
And just so you know, I'm not checking football scores. I actually have the question on my phone, so forgive me for using the modern technology for our program.
Fantasy football.
The question that we have for you today is, what fundamental American values are embodied in the Fourth Amendment? Subparts of that, why have Fourth Amendment issues been a persistent concern from colonial times until today? And as a further subpart, how and why does modern technology raise new concerns about the Fourth Amendment? You may begin.
The Fourth Amendment's requirement that government may not search or seize one's person or property that is absent of probable cause is rooted in the fundamental American values of preserving privacy and the preservation of our natural rights. An individual's expectation of privacy is and has always remained at the heart of the Fourth Amendment's protections against unreasonable searches and seizures.
As Justice William Brandeis stated in Olmstead v. U.S., the makers of our Constitution undertook to secure conditions favorable to the pursuit of happiness. They conferred, as against the government, the right to be let alone, the most comprehensive of rights and the rights most valued by civilized men.
The Fourth Amendment embodies the fundamental idea that individuals retain a basic right to privacy in their communications and possessions, into which no government actor can arbitrarily intrude. The government is restricted from excessive intervention through the oath of affirmation in defining what will be searched and seized. In the time leading up to the colony split from England, unjustified searches expanded through general warrants to the point where natural rights were violated.
The idea of probable cause became apparent through Lord Camden's 1756 dicta and end decree guarantee. The great end for which men entered into society was to secure their property. That right is preserved sacred and incommunicable in all instances, where it has not been taken away or abridged by some public law for the good of the whole. The case established a precedent that had a significant impact on the ideology of the Fourth Amendment.
Throughout history, the Fourth Amendment has been essential to individual rights. In Carroll v. U.S., the Supreme Court ruled that searching a person's automobile without probable cause was constitutional. The case has been used to increase the scope of warrantless searches and also increase the power of the federal government. It was violating people's privacy and property without a warrant. However, the court ruled in favor of the government because it violated the Volstead.
In 1982, U.S. v. Ross overturned this rule and established that searching a person's automobile without a warrant violated the Fourth Amendment. Even to this day, citizens still fear unreasonable searches and seizures, as demonstrated in the 2000 case of Indianapolis v. Edmond. As people drove through roadblocks, federal authorities used drug dog searches to prevent drug trafficking.
Since the police did not have specific probable cause, they were infringing on every citizen's right to privacy and the security of their property, much like the English when they issued general warrants. The rapid growth of surveillance and other technologies has also made concerns about privacy particularly controversial today. The expectation of privacy can be seen in U.S. v. Jones, where the issue of the technological implications of privacy has vastly changed.
Law enforcement officials attached a GPS to a vehicle. They used the device to monitor the vehicle's movements, which the court later determined violated the Fourth Amendment. With other new technological developments, individuals' expectations have adapted in order to keep up with the changing world. For example, the domestic use of drones has skyrocketed. Just this year, UNR added a drone miner to its curriculum. The minor explores the legality of drones, calling into question if the use of drones is in violation of the Fourth Amendment.
Unfortunately, it is still unclear when uses of drones are lawful and when restrictions are necessary. The use of drones with tools such as radar speed cameras brought up more controversy on individuals' expectation of privacy. This expectation is derived from the Fourth Amendment. However, there is no definite term for privacy in the Constitution, so the Ninth Amendment is utilized.
As explained in Griswold v. Connecticut, specific guarantees in the Bill of Rights have penumbras, formed by emanations from those guarantees that help give them life and substance. Various guarantees create zones of privacy. The citizens still have rights that are not necessarily stated in the Constitution, but are protected under the principles which the Constitution was created. Thank you.
Thank you. We'll now begin the question and answer portion of the discussion today. And I'm going to begin with one that I think is very applicable to you and this audience, and that is, do you agree that students on a public school campus should not have to meet probable cause standards that apply to general society? Why or why not?
Students should have to meet this probable cause because they are students and the school is representing is kind of like a teacher, or is kind of like parents for them. Teachers have the right to ensure that the students are becoming part of society, and in order to do that, they have to have probable cause in order to ensure that the students are developing good moral character.
As we saw in New Jersey v. TLO, it was the court ruled that school administration and teachers do not need a warrant. They just need reasonable suspicion to search a student's things. But police officers need either probable cause, consent, or a warrant to search.
Building off of what Kelsey was saying, the school officials have the right to search a person's bag if they believe that it is not furthering the educational mission of the school, and they have the right to check if what they have in their bag, as long as they have this probable cause, such as in New Jersey VTLO, is evidence.
Very good. You know, I'm just going to follow up to that because we talked about, you made a comment about searching bags, but it seems to me, as I visit high schools, that the one thing that is shocking from when I was in school was the use of these. Everyone has something like this today. To what extent do you think the school would have the right to search your phone?
Well, as Justice John Roberts said, applying established rules to new technology is going to be the real challenge for the next 50 years. And currently there are two cases, Worry v. U.S. and U.S. v. Cotterman, where the court does not have any precedent to determine rulings on those cases. And instead they must use the question of first impression. And this creates a difficult job for both administrators and the government when determining what's reasonable to search a cell phone.
And in the founders' creation of the Fourth Amendment, you can argue that they could never grasp what technology would come today. So when they were writing the Fourth Amendment, they didn't know that every kid would have these iPhones in their pockets that are more capable than most computers were 10 years ago. So we have to interpret the Constitution in our own way based on these technological advances.
And law enforcement should be restricted from searching through people's phones because they should have a warrant just on the basic difference between having something in your locker and having something in your bag. Because the locker is school property, the school officials have the ability to search it because you are storing something in school property. But if you have your phone on you or like in your bag, they don't have the right to do that because that's your personal possessions and it's your personal property.
Good. Thank you.
Okay, now, I'd like to have you to give me an example of, or the definition of the exclusionary rule, and then as it applied through Ohio, does it have any practical effect today?
The exclusionary rule started in Massey, Ohio, and it determined that any evidence obtained illegally without a warrant or probable cause is fruit of the poisonous tree, and is determined that it cannot be used in a court of law.
There are some exceptions to this exclusionary rule, however. For example, if police are trying to arrest someone and they flush drugs down a toilet, this goes against exclusionary rule.
And the exclusionary rule could be practical today, but the court also has to consider the ruling in Wolf v. Colorado, where illegally obtained evidence was used during trial. And that is also part of even though Matt v. Ohio overturned that, the court still must consider that opinion in current cases regarding warrants and the exclusionary rule.
The exclusionary rule could also be thrown out if the officer's life is in jeopardy, and if he may be required to apprehend a suspect and search him in order to make sure that his life is not in jeopardy.
The rule is still inherent today, though, because it checks the government from becoming overbearing and ensures that if you're going to obtain evidence illegally where you don't have the right to do so, it stops that from happening by throwing this evidence out. So it does have an extremely important, it has extreme importance today.
Why do you think that the Fourth Amendment falls under such great threat during times of national emergency and crisis?
This can be seen in the 9/11 terrorist attacks with the Patriot Act. The Fourth Amendment is more individually rights related, and so it's thrown out to protect the common good rather than the individual.
With the threat to national security, we see like the creation of TSA, and while your bags are being searched before loading airplanes, it's for the common good. You're making sure that weapons and bombs and other mass destructive weapons aren't being brought into the plane, affecting the other citizens.
And these minor infringements on citizens' Fourth Amendment still, like Carmen and Kelsey said, brings the national security to a level where it is most likely not going to happen again, or is trying to make sure that doesn't happen again. And that's why those minor infringements are reasonable in those times.
In times of crises, the Fourth Amendment is put in two categories of the common good versus individual liberties. And in time of emergency, it is common good in order to be searched so that you may be infringing on individual liberties. But overall, your life may be protected from these TSAs and people with bombs or playing, as my other colleagues stated.
Thank you. I'd like to go back a little bit here, and I think you touched on this in your prepared remarks, but from where do we get this right to privacy?
Although privacy is actually not specifically stated in the Constitution, it is implied through the First, Fourth, Ninth, and 14th Amendments. Especially looking to the Ninth Amendment, it makes it so rights don't have to be necessarily stated in the Constitution or Bill of Rights in order for citizens to have those rights. There's implied rights, and the right of privacy was already established when the founders were creating the Constitution.
This idea of privacy emanated from the English, including Magna Carta and the English Bill of Rights.
And Justice Louis Brandeis said that the right to be let alone is the most comprehensible right of civilized men.
Okay, this is a little bit of a broader question, and I think I heard a couple of you touch on this, but is there any circumstances where warrantless search would be justified?
Warrantless search is justified if the evidence is going to be destroyed immediately, like flushing drugs down the toilet or burning documents.
We can also see this if a police officer is in hot pursuit with a criminal, they have the right to obtain evidence without a warrant.
Another example of a warrantless search is when we see DUI checkpoints. And you can justify this warrantless search because the public was aware of these checkpoints beforehand. And while you may be infringing on some of these rights, you're trying to protect the common good by getting these influence drivers off the streets.
If someone is being arrested and they have been arrested on good grounds, they may be searched, and any property such as bags and cars that they may be in direct relationship around them may be searched in order to reinforce
An example of what John was saying is in California v. Greenwood, the court ruled that the police were allowed to search a man's garbage can because he had narcotic paraphernalia in the trash can that was on the public road and was open to be searched.
Just briefly here in our last minute, we've been hearing a lot about the NSA and the media. Does the NSA have the right to see my messages between me and my mom? What is your opinion?
I don't think the NSA does have a right to see your messages between you and your mom. If, for example, you were to say something in relation to a terrorist threat on USA, then yes, they could. But seeing as how it's a private conversation and your expectation of privacy is subjective and objective, the NSA does not need to violate this by looking at your phone.
Although they don't, I would agree with Carmen, they don't have this right. They do have the right to collect it just in case, let's say you die the next day. They have the ability to see this information and when an emergency like that happens, and to see what happened and what was going on with your conversations and such. They're not actually going through your information on a day-to-day basis. They're just collecting it.
Good, thank you.
Thank you. You know, time is up today. I'd love to continue this discussion. I think I've learned some things here this morning. How about a round of applause for this? I didn't know that you could get a minor in, what is it, a drone minor. Wow. You know, just as some comments about your presentation today.